right, Donnie Sims.
I think, wait.
Hi, Mr. Sims. You were arrested for grand theft and 2 counts of resisting an officer without violence. I will appoint the public defender's office for you.
Your Honor,
Yes, sir. I need a review for probable cause.
And, Your Honor, I do have Officer Yamoka who will testify.
Okay, let me review.
She's off today. She's off.
Okay.
Your Honor, as the count 1 judge, there's no value. In addition, Your Honor, it doesn't say, while the A form stated that the bike was stolen weeks ago, it doesn't indicate that Mr. Sims was the individual who stole the bike. So I would argue there's no probable cause for the grand theft, Judge.
Okay. There's an officer in court. Can you please state your name?
Good morning, Judge. Officer Isidro Jamoka, police officer of Superman Beach.
Okay, so Officer Yamoka, are you involved in this particular case? Were you on scene?
I'm not the arresting officer, no.
Okay. Are you familiar with the Deco bikes on Miami Beach?
Yes, I've been involved in several arrests, which involve the theft of the Deco bikes. There's 2 types of bikes that are available. One for Miami Beach, which has a value of $600, and then there's a second model, which is available in Miami, that some individuals bring from Miami over to the beach, and those are valued at $800. My contact person with the city bike is Mr. William Fajardo.
Okay. So I have no further questions for Officer Yamoka. I don't know if counsel has any questions.
Good morning, officer. In regards to, you stated that you were not the arresting officer for this grand theft charge, correct?
Correct.
So you don't have any information as to Mr. Sims being the person who actually stole the bike then, correct?
So the question was asked whether I knew the price of the bicycle that was involved in this case.
I'm sorry, I can't hear you.
The question, he said, you know what, he need to use that microphone, please, because that one doesn't work so well. Excuse me, Mr. White, he needs to use the microphone.
I believe the state asked me if I was involved in this case, and I stated that I was not the arresting officer. The only thing I was saying is as to the value of the bike, which I have good information. I've met several arrests before, which involved the Deco bike. There's 2 types of bikes.
I understand that. I got the prices for the bike, but my question is, you did not see Mr. Sims steal the bike, correct?
No, ma'am.
And you don't have any information that he was in fact the one that stole the bike weeks ago when it was allegedly stolen then, correct?
No, ma'am. I'm going by what the A form says and what the officer
Okay.
attests to.
Thank you. Judge, I have no further questions.
I just
Again,
have
there's
a
nothing to
brief
indicate
redirect.
that Mr.
Oh, you want to
Okay,
speak
how does
also?
the
One
Officer
second.
Yamoka, I'm
Yes.
sorry, just how does the Deco bike program work?
Sure. The Deco bike is paid by credit card by a renter. Once that renter uses it, what happens is the card is billed hourly or per day. When the bike is not returned, it's considered stolen, and the bike individuals are notified that this bike was stolen. What we do is we go ahead and look at the bike number, serial number. We call the representative. We give him the serial number. He goes, yes, there's an unauthorized use. That bike is not supposed to be on the streets. The person who's supposed to have the bike needs to have the 4 numbers or the 4 digits of the credit card being used. I'm not aware of the A form, but that is how it works, and that's how they're identified as being stolen.
Okay. All right, no further questions.
So, and then Judge, if I could follow up with the state's redirect. So then, officer, you don't have any idea whether it was the person who initially rented the bike didn't take it back then, correct?
Ma'am, I think you asked me that before. No.
So that was a different question that I asked you. My question is, based off the state's redirect a moment ago, you noted that if the person who rents the bike with a credit card don't take it back, it's considered stolen, right? That's what you stated a moment ago, right?
Correct.
Okay, and there's no information as to whether it was in fact the person who allegedly rented the bike, if he was the person that actually stole it or didn't take it back. You have no information in regards to that then?
In this case, I have no information like that.
Thank you. Again, Judge, based off everything that was stated, you, as the officer noted, the person who rented it with the credit card has to take it back. There's no indication that that person, one, was Mr. Sims, or that Mr. Sims took it from the person who never brought it back. So we would argue that there's no PC for the grand theft.
Your Honor, if I may add, there is a sign that's on the bicycle that says possession of this bike. If you're not the user, it is stolen property.
Okay.
And again, Judge, we don't have any information whether the person
Thank
who
you.
took it was the one that gave it to Mr.
Someone
Sims.
else here wants to speak. Can you, he has to be sworn in.
You swear firm testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Put your hand down, state your name for the record, please.
My name is John Dutzman. I'm from the Miami Beach Crime Prevention and Awareness Group. Your Honor,
And Judge, before this individual starts speaking, Your Honor, we would argue, Judge, that this individual does not have standing to testify in court. While he can appear in court to observe the proceedings as a community, he does not have standing to address this court in regards to this case because he's not the alleged victim. And we just
Your
want to
Honor,
make that clear for the record. So because we're objecting to any testimony from this person, he's not the alleged victim. He does not have any information about the case other than what was provided by the police officer. So we would argue, again, Judge, as I've noted multiple times, he does not have standing to address the court.
Your
Okay,
Honor,
one second. Let me hear from the state your
Great, so
response.
Judge, this is a representative from the community. I believe that he would have standing to address the court. He does have knowledge of the defendant's criminal history, and his impact that this defendant's had on the community in Miami Beach lately. So I believe it's relevant, and he would have standing to address.
I don't know. I'd have to hear the questions. Your objection in testifying is overruled. The state can call whoever they wish. And then if you don't agree with his testimony, you can object.
thank you, Your Honor. There is precedent for this. It's gone on for years. If a member of the community feels a person's a danger to the community, they're allowed to testify in bond court. This is Mr. Sims' 11th arrest in 12 months. By the way, Your Honor, he left, according to the police, he left a little message for you, or the judge on the A form. What the message that he left for you is Mr. Sims' attitude towards the community, in that he's been arrested 11 times. More outrageously, he was arrested in August and convicted for grand theft, and he's out. He had like 1 day probation. I don't know exactly what that's about. But then following that, he had 2 other arrests. He has a pending case of disorderly intox in which he was on the street on Collins fighting with sticks, holding up traffic. That case, we got bond on him, and the next day or whatever, he went to court, and he was released on ROR despite our argument in bond court to hold him. So Mr. Sims is in my neighborhood, works my neighborhood. He hangs out at our library. He's always on the boardwalk between 15th and 25th on city bikes, and he has a record for theft here. He's a convicted thief. And his arrest was in August, and he's out again. It's a 5-year maximum penalty. And I don't know how in the world he's out.
You haven't talked to the division judge who sentenced him, or be there for the sentencing. In the meantime, he's out on he has an open trial pending for possession of cannabis and disorderly intoxication.
Judge, for the record, I just wanted, for appeals purposes, again, to note that this individual does not have standing to speak to the court. He's not the alleged victim. Again, he's noting about Mr. Sims's priors, which the court can't see on its own. He should not have been allowed to speak to the court. So again, for appeals purposes, we're arguing that this individual who keeps coming to court does not have standing. And in previous occasions, I know our office has appealed certain individuals coming before the court who does not have standing, and we have won. So again, Judge, I want to note it strenuously, for appeals purposes, this individual does not have standing to address the court.
Does the state have any questions for Mr. Dutzman?
I don't. I'm just going to join in his request, Your Honor, for an increased bond perhaps. I will note that the defendant does have the 2 open misdemeanor cases, and he does have a significant criminal history.
Most of his cases were closed this year. I'm sorry, Ms. Howell, do you have any questions for Mr.
Your Honor,
Gutzman?
No, Judge, I have no questions for him because he does not have standing to address myself or the court. However, Your Honor, we would ask for either the standard bond or lowered bond. Mr. Sims is indigent. He's been appointed a public defender. While I do understand a lot of his cases were in 2007, the state is indicating that he has significant priors, and he does not have significant priors compared to other people who we've seen before. He has less than a page of priors altogether. There are individuals who have 8-10 pages of priors, so this is not significant priors. Again, while most of his cases came between 2016 and 2017, Judge, he's 27. And so for years before that, he did not have any significant or a lot of priors. So we would ask the court to take that into consideration when either setting a lowered bond or the standard bond, and we would object to the increased bond at this time.
How long has he lived in the Miami area?
He's been living here for 3 years, Judge.
Judge, also one further argument, the defendant does have prior failures to appear in court, which I believe are relevant. There was a bench warrant quashed in April of 2015, also a bench warrant quashed in November of 2016, January of 2017, March of 2017, so the defendant does have a history of failing to appear in court.
And for the record, that means if it was quashed, that means he went in and addressed them. He wasn't picked up on them. So we would ask the court to take that into consideration as well.
No, Your Honor, just to clarify, those are arrests on bench warrants. So those are just represent time that he was taken into custody on the bench warrant.
Does he have any priors from out of state?
From out of state, nothing came up, Your Honor.
Good. Yes, sir.
Your Honor, since the public defender is attacking our ability to appear in court, we'll
I
note...
overruled the objection. I allowed you to appear
But
and
I would
testify.
like to note for future cases that we have 1,300 people in our group, and that the public defender's intention is to prevent us from testifying to the generic danger to the community. We intend to take action against the public defender's office.
Okay, well, the public defender is doing their job, just so
And
you
for
know.
the record, Tony, for the record, could you please, if I could get a copy of what was just stated a moment ago
You
for
have-
appeals
you have
purposes
to-
as well?
You have to request.
I just want to make it clear for the record, because since we're talking about taking action, Judge, as noted, for appeals purposes, this individual does not have standing. While the court can consider his priors, to which the court has, this individual does not need to come in court to read the court Mr. Sims' priors, because the court has it before your Honor. So there's no need for him to come into court, and we stand by that argument. So if this individual want to take action against the public defender's office, by all means, because our office is well aware of this individual coming into court and does not have standing to address the court. So again, as we noted, for appeals purposes, we would object to him coming in today and any other days.
Okay, a courtroom is an open public forum, and I try and conduct this court in accordance with law, and I try and do that every day, and I'm doing that now, I believe, with Mr. Sims. So that being said, I'm going over Mr. Sims' prior convictions. From 2016, he received a withhold of adjudication on November 21st, 2016 for resisting an officer with violence. On, let's see, September 18th, 2017, resisting an officer without violence conviction, CTS. Grand theft, third degree, adjudication withheld September 20th, 2017. So you're talking about two contacts within the last month. Or one conviction, one withhold within the last month. Then you have a conviction for trespass September 11th, 2017. CTS, it looks like. There is a carrying a concealed weapon, resisting an officer without violence, both convictions from March 16th, 2017. On January 13th, 2017, there is a withhold of adjudication for possession of cannabis, resisting without violence. And he has other contacts which were null pros, which were all null pros. So that being said, I want to note the comments in his in the arrest affidavit that Mr. Sims allegedly stated to the police officer. As the officer attempted to place the defendant in custody 2 times, he resisted without violence 2 times. I could only get 1 handcuff on his left wrist, as he said, quote, "You ain't taking me to jail. It's F that," and he said the complete F word, not the shortened version. "F the judge, F all of y'all." quote unquote. So, and then there was no further incident and he was taken to jail. The city bike was returned to the on-site representative after being photographed by crime scene. So that is what I have before me. There could probable cause for one count of resisting, which I believe I did not hear the public defender make that argument, but I'm stating that is, you can only be convicted of one count of resisting. So there's only probable cause for one count. There is probable cause for grand theft for the Deco bike, which Officer Yamoka testified to, that the value is $600. So that being said, count one, grand theft, I'm increasing the bond. I believe an increased bond is warranted based on the numerous convictions from this year, as well as, just the numerous convictions from this year. $10,000 bond, count one. Count two, resisting an officer without violence. I'm going to make that bond $1,000, and count three is an ROR. Good day, sir. Thank you, Officer Yamoka, for coming in. Thank you, Mr. Dutzman, for you coming in.
Okay, and Yamoka's here on one
Thank
more
you, Your Honor.
case, which we're passing.
Okay. Which is the case?
That was Wilfredo Lopez.
Wilfredo